Hi, my name is Raul Guajardo. I'm a personal injury lawyer that has been serving South Texas for over 20 years. Many clients ask me how injury claims are handled by the adjusters, so I'd like to discuss that here with you today. An insurance claims adjuster will employ a variety of negotiating tactics to get you to settle your claim for as little as possible. Let's look at the 4 statements the claims adjusters might make in conversations with you to learn what the adjuster really means and how you should respond. Number 1, when the adjuster says, "I'd like to take your recorded statement," what he or she really means is, "I want you to commit to one version of what happened right now so that I can use it against you if you try to change your story later." Adjusters are paid to investigate claims and gather facts. The linchpin of their investigation is your statement. And believe me when I tell you, the adjuster will try to get you on the phone or in person as soon as possible after the accident. Why, you may ask? Symptoms often get worse in the 24 to 48 hours after an accident. They want to catch you while you're still in shock and before your symptoms really set in. The adjuster will use your statement to A, commit you to a version of what happened, B, question your credibility if you correct an innocent mistake or add an overlooked detail later on, C, look for interpretations in your statement that reduce your claim's value, and D, they want to disprove injuries that you suffered, which likely worsened after the statement is given so early in the process. Number 2, when the adjuster says, "Please sign this medical authorization form," what he or she really means is, "Please sign this form so that I can gain access to your entire medical history, going back to the womb, and perhaps find something I can use against you." Adjusters frequently ask claimants to sign a medical authorization. This gives the adjuster permission to obtain copies of your medical records. The problem is that most of these insurance company authorizations are broadly drafted and give adjusters the ability to go into a claimant's complete medical and psychological history, as opposed to just obtaining records related to treatment for the accident itself. This allows the insurance company to pry into pre-existing conditions and medical or psychological issues you may have had. Most claimants who do not have a lawyer will sign these medical releases because they think that if they cooperate with the adjuster, this will increase their chances of getting a prompt and fair settlement. Usually, signing will come back to bite them later. Number 3, when the adjuster says, "Why do you need an attorney? I'll work with you on the claim," what he or she really means is, "Please don't call an attorney. When an attorney gets involved, it becomes much harder for me to push you into a fast and cheap settlement." When the adjuster deals with an unrepresented claimant, the adjuster has the upper hand because he or she knows how the system works, and they have been trained in negotiation. Once a personal injury attorney gets involved, the adjuster loses his or her advantage. As a result, to discourage you from contacting an attorney, the adjuster might say, "Your claim won't be any more valuable just because you get an attorney." That is false. The price tag of a claim almost always goes up when an attorney gets involved. They may also say, "Why do you need a lawyer if I'm looking out after your best interest?" That's not true. The adjuster is actually seeking the opposite. He or she wants to pay you as little as you will accept. Or they can also say, "If you get a lawyer, we will have to hire one as well to take your deposition." That's true. But if the case proceeds that far, a deposition is nothing to fear. You're merely giving your statement in person with your attorney at your side. They also often say, if you hire a lawyer, it will slow down the claims process. That could be true, but it is also likely to result in a much better outcome for you. Lastly, number 4, when the adjuster says, "If you don't accept this amount now, we will withdraw all offers," what he really means is, "Please take this low offer so I can close your file and get it off my desk." This is often a bluff. If your case is worth $20,000 today, it will likely still be worth $20,000 tomorrow or the next week or the week after that. If the claims adjuster is not bluffing and he withdraws the offer, consider that withdrawal an invitation to file a lawsuit. So to recap, don't give a statement to the adjuster without a lawyer. Require limited language on the medical authorization forms that you may sign. Understand that the adjuster really does not want you to retain an attorney. Do not fear the adjuster's threats of withdrawing all offers. Compare the adjuster's last offer to your claim's value, and then decide whether to accept it. If you need help evaluating your claim's value, call us. We will be glad to guide you. There is never a charge to consult with us, whether you hire us or not. So you have nothing to lose by calling us. You can call us at 956-318-3200. Thank you for watching, and we look forward to being of service to you.